Thank you. So now we turn to our discussant, Uladzislau Belavusau.
You can hear me, right? Thank you, Nadia, for the introduction. Thanks also once again to the organizers. It's a pleasure to be second year ahead present at this conference. Last year I presented. This year I've got an interesting task of discussing for promising papers, for promising researchers, but my task is quite complicated by simple reason. I'm a lawyer, and apart from Cosmin, 3 other papers are submitted by social scientists, so for me it's quite new to look in the interdisciplinary lenses into papers which are strictly speaking methodological rather than substantial. So anyway, let's see what would be the result. The first paper by Cosmin Sebastian Sercel is a very eloquent account of the Romanian legal history of the post-war, post-Second World War period. He suggests sort of 2 visions of transition in Romania. First is, strictly speaking, post-Second World War, the second occurring after the decommunization. He looks into the state of exception. He gives a very interesting retrospective of what happened exactly in the, let's say, pre-Nazi period. So we've got the history of the King Carol II, instauration of Marshal Antonescu regime. We understand better what the role of the Iron Guy there, and ultimately what's the role of the law plate in all those interesting transitions occurring there. So he talks about that legal post, yeah? How should we treat stricter sense of the state of exception? Is it the absence of law? Is it the absence of rights? And he comes up with the conclusions which are largely drawn by the trial of Marshal Antonescu. I would say that that's heuristically most fruitful part of that paper. Something which I would perhaps find plausibly linkable to this account, to the whole history narrated in numerous social sciences about the trials and the role of trials. We've called the whole tradition of the sociology of law in society actually looking into trials, starting from the trial of Socrates or going into the trial of Jesus, etc., etc. And perhaps something which almost backs as the analogy when we talk about the trial of Antonescu is Hannah Arendt's account of Eichmann's trial in Jerusalem, the famous book on the banality of evil. So I suppose that that piece is a part of a bigger project, and you may have, of course, come across Hannah Arendt's analogy. What strikes me in the numerous trials occurring after Second World War in Central and Eastern Europe is actually the similarity of the approach taken by the young Israeli state in constructing a new identity essentially based on victimhood. So all those trials are dealing not necessarily with the clarification of the historical record, what we see very clearly with the Antonescu trial as well, but with establishment of the guilt, with naming, claiming, and essentially very often mingling the issues of who is the perpetrator and who is the victim. So what Cosmin does in his paper is actually masterfully exposing that what occurs in the trial of Antonescu is not the clarification of the historical record, is not even necessarily the punishment of the perpetrator, but most importantly, the state creates an institution through the Ministry through the Ministry of Justice it creates a mechanism to create a victim out of the state itself. So what is ultimately clarified is who is the victim. An interesting thing for me about this paper, and I think that's something that almost admirable thing about the narrative of Cosmin, the way he writes is his post-structuralist language. I like the way he plays with metaphors, and I would like to draw the attention of the audience to the title of his paper, Anxieties of the Nomos, Fascism, Communism, and Legal Discontinuity in Post-War Romania. Well, something which I perhaps missing in the paper, and which is easily explainable by the certain frames we've got when submitting papers in the conference, is the terminological clarification of what is actually meant by the anxiety and by the enormous for the purposes of the, let's say, Antonescu account, the trial account in Romania. If we look at the way anxieties are dealt by the psychoanalysis, we could establish a wonderful parallel to actually the way law clarifies historical record, or at least pretends to clarify historical record. So, what is important for the psychologists dealing with whatever anxiety is to identify the problem. And the problem is usually either traumatic, right? There is some foundational memory which creates the environment ultimately for that nervousness situation, for anxiousness of a patient, or it deals with the hypertrophied guilt. So when we are talking about historical record, memory loss, etc., we are dealing mostly with that hypertrophied, exaggerated guilt. What the trial of Antonescu, or the trial of Eichmann are ultimately establishing is actually revealing the patient, and the patient in this sense is the nation, be it Romanian nation, be it the guilt created out of Holocaust, and saying to the victim, and in the ultimate place that, saying to very often even to the perpetrators that they actually belong to the sector of victimhood. Whether it is actually the meaningful way of dealing with traumas, with dealing with anxieties, remains more than questionable. So technically, apart from building self-esteem of a victim, of a patient, apart from working with that guilt, the notion of guilt, law, is that almost psychomechanism, talking metaphysically about what law actually performs in constructing social reality, should have created a cognitive behavioral environment, a certain environment for discussion, a space, semiotic space where history is discussed in free and unrestricted mode. So technically, although it sounds almost ironically, less law we've got in construing history is the better. Because that's one of the foundational modes of actually dealing with anxiety. Well, perhaps I would leave it just open as the point of reflection. I don't know if Cosmin would like to comment later, or perhaps since it constitutes a part of a bigger piece, you've got certain thoughts on this. And I go ahead with the presentation by Elleros Miller. Elleros Miller draws an account which is completely new to me, I should admit, identifying what she calls subject positions. Subject position in regard to social discourse. She brings lots of analogies, how discourse could be defined, starting from Foucault's discursive formalities, Bourdieu's habitus, webs of meaning, Husserl's life worlds. And she says that subject position is a very important element when talking about the nexus of discourse, transitional justice, politics of memory. So her paper, strictly speaking, is methodological. So what she tries to do while working with an impressive number of the documents, of the legal documents, is to reveal actually the sectors and the subjects covered by the law on transitional justice. So in her paper, as the conclusion, she demonstrates the let me look at the paper. She demonstrates what she calls inventory of subject positions, so those identified terms. And that inventory is supposed to be applicable methodologically for future research. She wonderfully exposed in her own presentation what subjects mean in her identification, how they relate to the notion of identity. So my questions will be rather about the classification and the methodology of classification itself. What I like about the approach of Ella is that she goes beyond the traditional accounts in classification of transitional justice and, for example, includes illustration there. Even more interestingly, for somebody working with freedom of association, freedom of expression, is that she brings civil and political rights into the nomenclature of transitional justice. And especially when talking about Poland, I think that's the case when civil and political rights and the way freedom of expression, freedom of association, freedom of religion, etc., constructed by the Constitutional Tribunal, higher courts, becomes extremely important to understand the position of different subjects vis-à-vis transitional justice. So Poland is the wonderful example of the exposition of the problems related to communist symbols, hate speech, glorification of authoritarian regimes, ultimately discussion on the uncomfortable elements of the Polish history, talking about Jedwabne, and an attempt to criminalize what was called pomówienie narodu polskiego, the defamation of the Polish nation, right? So civil and political rights are actually becoming extremely important. My question deals with, since when talking about civil and political rights, we very often deal with the borderline between, strictly speaking, legislation and courts. What's your analysis is about? Is it about the politics of the legislator or the politics of the court? Because my feeling that in social sciences, those genetically sort of arose differently, so they have different substratum. They have different scholarship, engaged in those studies. And my feeling that your research offers a very rich framework which covers both of them, but still I'm interested how the politics of the courts, especially when related to civil and political rights, stands vis-à-vis the politics of the strictly speaking legislators. Another interesting thing which I've noticed about your inventory is that in the positions of the subject positions you've identified, ethnicities are practically absent. It's almost fascinating when we are talking about the multinational heritage of the last Rzeczpospolita, right? So when you talk about ethnicities, you've got a very interesting subdivision. You mentioned Poles, you mentioned Polish citizens, Polish nation. Interestingly, from a Polish autocephalous Orthodox Church, but then let's say Jews or Roma, or very important element of discussion in Poland, Germans on the one hand, plus the population of the borderlands, Kresy Wschodnie, so Belarusians, Lithuanians, and Ukrainians are absent from that picture. So I wonder what made you include Poles there, right, but to exclude other ethnicities from that inventory. Does it have any methodological explanation? The third paper, the paper of Eva Petaje, is once again an interesting methodological account. I'm very glad that Eva clarified that, or sort of built up something substantial on that methodological analysis within your presentation, exemplifying it with concrete stances, legal stances of the legislators, courts on the issues of perpetration, perpetrators, victims, history, analysis, property restitution, etc., etc. In her paper, once again, like in the paper of Ella, she draws the methodological picture, how to start actually dealing with analyzing, classifying the transitional justice questions, especially with regard to memory in 3 Baltic countries. As well as Ella, she packs that Grodzki typology, so she describes retrospective justice spectrum in terms of cessation and codification of human rights, rebuke of old regime, creation of truth commissions, ultimately criminal prosecution. Something which is absent for me in that picture of Grodzki is that governance of identity, creating of new post-transitional identities. And I will try to explain it a little bit later. Before, I would like to return to another typology which you suggested. If you have an opportunity, I would very much appreciate if you could return with the slide where you suggested the 3-level typology of administrative, criminal, and yes, the very first one. So what I find particularly interesting in terms of the contribution of Eva into the whole discussion on transitional justice is her very thoughtful attitude to the classification of how civil measures stand vis-à-vis criminal measures as far as the account of transitional justice is discussed. And she's right that, strictly speaking, there is nothing new about this typology of, let's say, civil measures vis-à-vis criminal measures as applied to perpetrators and victims. Obviously, we see different sort of governances, different regimes of memory, if we talk about history, for example, yeah, for the purposes of our conference. But what is interesting for me is that you bring that new level of political administrative, let's say, justice, transitional justice. And when looking about Baltic countries, that element becomes fascinating for me. And here where I'm interested about that element to which I returned early, about the governance of identity, creation of new transitional identities of Estonians, Latvians, and Lithuanians in the recent 20 years. There are certain measures, and briefly, you glossed over them, which for me do not fall either into administrative or cultural constructions. For example, you talked about the attitude to the construction of the memory of the Second World War, the role of the Soviet occupation, the space of citizenship, yeah, and citizenship exclusions occurring in Baltic member states. And although by no means denying the fact of the Soviet occupation of 3 Baltic states, for me it remains sort of questionable to which degree we can take Stalinist regime as constructed in the imagery as exclusively being foreign, yeah, as an excuse to construct a somewhat xenophobic transitional identities actually in all 3 Baltic countries through the measures which are often portrayed as belonging to that symbolic representational level, yeah, but in fact which operate on the level of political administrative inclusion. So let's say the status of the non-citizens of Latvia, yeah, as a special category in Latvia, linguistic rights in Estonia, prohibitions on historical revisionism to a certain degree in all 3 countries, or let's say names politics in Lithuania, which even sometimes doesn't attack, let's say, the Soviet heritage, but very often limits the possibilities of minorities. Let's say the non-possibilities of the preservation and transliteration of the Polish names in the Lithuanian identity document. For me, that's once again a side of the same phenomenon of the transitional justice, and very unfortunate approach which takes Stalinism and occupation as an excuse to construct that rather xenophobic identities, right? So my question is, how would you actually put those elements of transition, whether we could put them into symbolic representational level and political administrative level, because I suspect that then colors may differ, right, in the ultimate tables which you create. Anyway, thanks for the interesting account to all 3 speakers. Now I've got roughly 3 minutes for the most difficult task. We've got 1 speaker, and I'm entitled to speak in the absence of that speaker about her paper. It's Anna Luleva, for a PhD student at the Institute of Ethnography and Folklore Studies, a person I've never met, but a person who submitted an interesting paper. It's titled Justice Policy and Memory About Communism in Bulgaria, Dynamics and Current Debates. Well, in the mode which is very similar to the portrayal of, let's say, Kosmin, Anna talks about 2 levels of transition. Transitions occurring after Second World War, and transition which the country, in this case Bulgaria, undergoes throughout 90s, 2000s. And she looks at the effect of that transition on the politics of memory, on the construction of the identities after 1989. What she identifies is that memory enters that scope of this, let's say, semiotic scope of the discussion, often legal discussion, portrayed as duty, as almost that citizenship duty. So she unpacks the idea of political justice as related to the category of the repressed people. So I think that the political discourse of the transitional year in Bulgaria was essentially centered, focused on that element, or that rhetoric of the repressed peoplehood. And it's not just the realm of symbolic representational justice, it's the level perhaps of administrative justice, because since August 2010, it also entered the space of law. So we've got the edict on the repressed peoplehood as related to the year 1945 when the Red Army entered the territory of Bulgaria. She also discusses 1990s lawsuits reviewing the verdicts of the People's Court, so largely communists driving decisions of 1944. She exposes the way law enters the construction of memory in Bulgaria by virtue of the ruling of the Council of Ministers commemorating day for paying homage to victims of the communist regime. The so-called the Day of the Murder, 1945, a theme which is largely discussed by the different political fractions, right to left, in Bulgaria, very often misused for populistic rhetoric. Finally, she exposes the so-called mega trials of the 90s, dealing with the issues as diverse but related to history and to the largest theme of our today's conference about workers' camps, Chernobyl case, the revival process. And she comes up with the eloquent conclusion, which I think to a large extent is attributable to the whole of our panel. She says that Bulgarian retributive justice is an example of something which is unsuccessful, uncertain, and inconsistent. And it sort of reveals that people lose trust in retributive justice. So perhaps it is applicable to all situations discussed, Romania, Baltic countries, Poland, etc., and it demonstrates what Eva called hands-off approach. But to say a couple of final words, I would like to be a bit provocative and say that maybe it's actually a good thing too, returning to the anxiety of the norms. Maybe the purpose of the law is actually not to punish and establish the guilt, very often shifting it, right, in populistic way, but to create the maximum sphere, space for this discussion of the free discussion of memory and sort of creating the broader paradigm of transitional justice environment in those transitional countries. Thank you very much.